Welcome to Inherently Distinctive.
Welcome to Inherently Distinctive with attorney Mark Goodman. Mark's practice focuses on patent law, trademark law, copyright law, and business law related to innovation. I'm your host, Sophia Morales, and today's episode is Startup IP Pitfalls, What Founders Miss Before They Launch. Welcome back, Mark. I'm so excited to be talking about this with you today.
Yeah, I think this will be a fun one. Let's hit it.
Yeah, well, okay, let's just start with the main meat. What is the number one IP mistake that founders make when they launch?
I'm not sure I can answer like the one that's the most common or something like that. It's hard for me to tell. But what I can say is the biggest mistake, that the most devastating mistake that is common, is if you have a new technology and you don't get on file with the patent office within 1 year of launching the product, right? And we talked about this a little bit in one of our other podcasts, but we can go deeper now that you bring this up, which is that our patent system requires that you file some kind of patent application early in the process, right? So in the United States, if you were to start selling a new product, let's say today, right, you would have a 1 year deadline, non-extendable, statutory. You're screwed if you miss this type of deadline, right? You can't beg the judge for forgiveness, right? To file some kind of patent application, or else you forever lose your right to do this. So let's say
Ouch.
July 1, 2025, launch the product. You've got till July 1, 2026 to get on file, right? Or else this is public domain. Now, I always explain to people why we actually have this. It seems like, what is the law doing here, right?
Yeah.
But it does make some sense when you think about it, because what we're trying to do is to protect an innocent competitor, right? Because for patents, we want people to be able to patent things to encourage people to create new innovations and bring them to market. But we also, at some point, want competition to bring down prices, improve quality, et cetera, right? These are competing interests that the government is taking into consideration when we make these laws, right? Well, so let's say you come up with a new product, Sophia, right?
Yeah.
And it's out there, it's launched, it's selling like hotcakes. I'm like, damn.
Yeah, Sophia's widgets.
Got a heck of a product out there.
Yeah.
And I'm a business person, and I want to, you know what? Maybe I want to jump into this business and compete with her, but I certainly wouldn't want to step on your toes in terms of intellectual property. I'm not that kind of business person, right? Those business people do exist, by the way.
Yes, they do.
Right?
Absolutely. There's a line of them behind you.
I'm presupposing that I'm not one of those types, right? And so I'd look, well, is she marking it patent pending? No. Does she describe it as patented or patent pending on her website? No. Do I even hire a lawyer and do a search? Nothing. You know what? I now invest $1 million, build a competing product, and compete with you. It would be unfair for you to then go get a patent and kick me out of this space, right?
Okay.
So that's why you got to get this done early. And one thing to know too, for people that are interested in international patenting potentially, is that 1 year grace period that we have, that is mostly only the United States. Most other countries, you have to be on file prior to launching the product.
Yeah.
You don't get any time.
It kind of begs the question, why would you wait? Why would you not just upfront, slap the patent on it and pee on the bush?
Well, I mean, here's the thing. It's like, it is like, when you think about this rule too, if we didn't have this rule, it would actually make a lot of sense, arguably anyways, to just start selling new products, see what sticks, then spend a bunch of money on a patent lawyer and get the patent, right? It's just the law makes you do it the other way for the reasons we just talked about, right? So, I mean, some people just either they don't know, or they don't want to spend the money, or, they just, all kinds of reasons, they're distracted, right? I mean, starting a new business is a very, very difficult endeavor.
Well, yeah. And a lot of people, I know there's some chatter in the entrepreneurial world about just keeping it a trade secret.
Okay, that's another entire topic that is, but it's a one we can summarize pretty quickly here, which is that is an option, but mostly in some circumstances, mostly it's not an option, right? So think about this. the formula for Coca-Cola, right?
Right.
Probably the most famous trade secret out there, right? That formula, they could have patented it, but if they did, that patent I think would have expired in 1903, is
Right.
what I remember. And in totally different world, right? But the thing that's different is that for most types of products, this doesn't work because a trade secret does not protect against reverse engineering, right? So,
Oh,
Sophia, if you and I buy a bottle of Coke at the store, go home to our lab, and somehow figure out exactly how this is put together and
I
create
know
our own
people
competing
who can
product.
do that.
Well, you actually can. It's legal
Yeah.
to do that. It's just no one's been able to really make it taste exactly the same, right? Sure, you've got the ingredients on the side, but you don't have how each step by step how this is made, right? You couldn't call it Coca-Cola or anything confusingly similar because you'd be violating trademark there. But you could come up with your own competing soda product. It's just nobody's been able to quite match it, right? But for most products, like if you come up with a new pen, you don't think some engineer could take apart this pen and figure out how it works? Sure they can, right?
Yeah.
So if you got a fancy new invention, a type of pen, you need to get on file with the patent office. That's really the only way. So I'd say at least 95% that's what we have to do. But in certain circumstances, people, if you have a formula of, let's say you have a chemical type formula, a type of paint formula, a type of an algorithm, right? Those types of things, you should really consider the trade secret route. And you have to pick because trade secrets and patents are mostly incompatible because patents are public and you have to describe the invention in full detail to get a patent. It's one of the requirements. So for instance, if Coca-Cola had patented it, the entire formula would be in that patent document, which would be public.
And then when the patent expired, there would be a half a dozen other soda companies that could go out and start making it.
Right, exactly.
Okay, so back to Zophia's widgets. I've got my widget. It's selling like hotcakes. I bought a domain, Zophia's widget. Does this mean I automatically own the brand?
So no. So it's interesting that the domain name is just, what are domain names? They're just stuff that whoever invented the internet came up with, these little combination of characters and together that create a single website, right? And just basically a trademark trumps a domain when push comes to shove, right? Like there is actually a process with all of these domain name hosting services, I guess you'd call them, that wherein if you can show, hey, I've got a federal trademark registration covering this, you can go through that process and kick people off of domain names that are the same or similar to your trademark. Right.
Because they can't hold them hostage anymore like they did in the early days of the web.
Right. And incidentally, the whole domain name thing, just as an extra aside here, bonus credit for folks, is that from my understanding, talking to experts in internet marketing and so forth, the domain name stuff is not nearly as important as it used to be, right? Because almost every other week, I get a spam email in my box that says, hey, do you want to have patentlawyerofamerica.com? Just send me $800 and it's yours. And my
well, 800 would be a cheap steal for that one.
Right. You don't need it because everybody just Googles what you want and then Google finds the thing. It's not in the early days of the internet, that might be worth it. Something like that, right? Arguably, because hey, people would go to that website, but now the searching is so much more sophisticated that it will find the content you're looking for. Very rarely are you having to punch in exactly the website. So for instance, you could Google my name, you could Google Goodman Law Center, you're going to find me very quickly. You don't actually need to have the URL memorized or written down to find what you want anymore. So
it's not really so much the domain name, but like a trademark. And so I've got my website out there. How risky is it for me to delay filing my trademark?
Well, here's the thing. It's like, I will say this, a lot less risky than delaying the patent filing, right? Which is why when I'm working with people doing a startup launch, I always explain it this way between the patent and trademark side is the patent side is more urgent, right? They're absolute drop dead. If you don't file this, you could be SOL here, right? Trademark, not so much, but there's still significant negative consequences to waiting, right? Because if you wait, well, someone else could file a trademark application that is the same or similar to yours in the same or similar industry. And that person will then have the priority position, right? Now, trademark law is a little different than what people think, right? Because actually first use in commerce can trump first to file, which is interesting. Most people wouldn't believe that's the case, but it is the case. Still, however, if you are the first to file, you are in the driver's seat if there's a dispute there, right? All of the burdens of proof, burdens of persuasion are going to be on the other party if you file first, in terms of who launched this first, and you're just in a much better position than you would be otherwise. So, and, quite frankly, trademark applications just aren't nearly as expensive as, let's say, patent applications. It seems to me to be worth getting at least your core mark, right? Name, logo, let's say, at least on file early. And then you can keep building over time as you develop your branding more and if the business grows.
So I've got my Zofia widgets. I've agreed that it makes sense to do both of the patent and the trademark filing. Should I be filing this under my own name or the company's name, or how does that work?
Okay, so let's split the conversation between the patent and trademark side here a little bit. And if you have copyrights, you can lump that in with the patent side. So for patents, okay, patents are treated like property, right? A patent belongs to the inventor initially, right? Unless there is some sort of assignment or an obligation to assign the rights of the patent to some other entity. So for example, if you work at a tech company, you're going to be under an obligation by your contract and actually now by the law anyways, even if they screw up the contract, to assign the rights to the invention to the tech company that's paying you to come up with these inventions, okay? And that makes sense, right? Otherwise, you could just use your time as an employee, invent some stuff, and run off with it.
Yeah, exactly.
Like that, right? Obviously, right? So the reason why I'm driving at this is that for patents, I'm not going to say it doesn't matter. There's some good strategies here, but there's nothing that's going to totally mess you up, right? You could file it in your own name, later assign it. Patents are very flexible in that way, right? What some of my clients do is we set up an intellectual property holding company, have the patents filed in the name of the intellectual property holding company, and then execute a license agreement between that holding company and the operating company that's formed, right? Why do we do that? Well, let's say there was some god-awful lawsuit in the operating company. Well, we could terminate the license, and then theoretically the creditor couldn't reach the patent. It's a lot like, imagine, Sophia, you're driving around and somebody rear ends you, right? You can sue them, right? And let's say they've got a house, putting aside homestead exemptions for now, you could maybe take the house to satisfy your claim, right? But what if they're renting? They're renting a house from some other entity. You can't take that. That's not part of what you can take, right? So there is kind of an asset protection strategy to having this separate company sometimes.
Right. Well, and I'm thinking, if you've created something and now you're bringing in partners, that might also be another reason to go this route.
Correct. I mean, as long as people understand it and things are disclosed, because I found for startups, one of the negatives to doing the intellectual property holding company strategy is that sometimes if you're soliciting investments, the investors get a little spooked, right? Because they're like, wait, I'm investing in this company, and wait, it doesn't even actually own the patent. It's just licensing it, and I'm freaked out and worried about this, right?
Yeah.
And so, but depends on the situation. That's just a conversation I have with folks. And you could do the same thing if you have copyrightable material and have that all together too. So you wouldn't need separate companies. And part of the strategy, the reason why it can work is that holding company has no liability because it's not actually doing anything in the world where it could be sued, right? Some people say, well, I could just hold it personally and license it to the company. Well, but then your creditors, if you get in a car wreck, could take the patent, right? So that's not as good either. And none of these strategies are perfect, right? Once you get into
Yeah.
the legal system and judges say, no, I don't agree with this. You're just going to pull this out and do this. But it still on paper works. And you put yourself in a much better settlement position if you had a disaster than if you didn't do it. With trademarks, I do not anymore. I've done it in the past, but I've made a decision that I don't think it's advisable to put trademarks in like a holding company, for instance, even though you can legally do it. But trademarks are just a different type of animal because they are tied to use in commerce. And who's
Right.
using it in commerce? Well, it gets dicier if you have some entity other than just the company that it's selling, collecting the money for the sales, and running the business, owning the trademark. There's just some pitfalls there that aren't worth the benefit. So for trademarks, I think it's just simple. Whatever company is selling this product owns a trademark. And again, put it in your own.
I can see where that would make sense too, just because back to your example of something terrible happens and you're sued for a bunch of stuff that's happened under this company, you might want to actually walk away from that trademark depending on how ugly it got, right?
Yeah, it is interesting. There are like interesting cases like this because one of the things about trademark, we've talked about this before, is that trademarks can last forever, which is one of the awesome things about trademarks, right? Patents and copyrights eventually expire, right? But they last forever if you can keep proving periodically that you're using them in commerce, right? And so they're not like so much assets that can be bought and sold as easily, even though you can do it, right? There have been cases where their companies have gone bankrupt and then like a lender ends up with like a trademark. Well, what are they going to do with that? Right? Because they got to get someone that wants to use that brand and take over that brand. It's not like they could just, very easily like a, piece of real estate, just flip it, right?
Yeah.
It can be done, but it becomes complicated for them. They don't even realize. They think that, we've got a mortgage on this great asset. Well, then what do we actually do when we have this asset? We've got to sell this product or else we don't have the asset anymore. Or someone has to be.
Right. We have to sell it to somebody who wants to use it. Yeah.
Or they can take over. So it becomes complex there.
Yeah, I can see that. So back around to IP law. What's a priority date and what does that really mean?
Okay, so priority date really is the filing date of your application for trademark or patent and the one that sort of counts. So let's take a patent example here. So let's say, if you file on an application on July 1, 2025, well, July 1, 2025 is your priority date. And what that means is that if the patent office is evaluating prior art, right? Because that's what happens when you file a patent application. They're going to look at other things that are out there that have been either filed as patent applications or patents or other printed publications or other products on sale they can find and compare them to what you claim as an invention, right? So, but they're only going to be able to do that for something that is published, sold, or filed before your priority date, right? Because if it's happened after, well, it doesn't count. You're before them anyways, right?
Right.
And so that's where the priority date can be important. And on the trademark side, it just has to do with who's in that priority position. Like I talked about before, whose burden of proof is it that they're really ahead of the other one? Who's got that leg up if there is a conflict on, people going for the same mark or something very, very similar in the same area.
Well, and thinking about starting up Sophia's Widgets, for example, when I'm developing this, a lot of times before you're really a real company that's selling things, you'll work with outsourced contractors, developers, labs, that sort of thing as you're making your thing work. Can you accidentally give away your IP rights when you're doing this?
Well, there's a few things that might be concerning here, which is that one is that remember when we talked about the on sale bar, right? Maybe I could have been more complete. It's not only like you have to file within 1 year of a product going on sale, but you also have to file 1 year within the time frame of a product being publicly disclosed. When I say publicly disclosed, in enough detail that somebody could make and use the invention fairly easily, right? And so there is some risk, like if you're dealing with certain contractors, well, what if they leak the information, right, and it becomes public somehow, right? Especially with social media, things can get public quickly, right? So that would be one problem, because now you may have this time clock to file going before you even know it is, possibly.
Oh.
I haven't run across that exact issue in my career, but that concerns me. So, as well, if you're working with just a good practice, if you're working with some contractors on developing it, just make sure the contract very specifically states that all the intellectual property is owned by you as the company, right? You're paying people to do this with employees. You should still do this, but it is at least assumed by the law. And with independent contractors, it can be a little bit dicier, so it's more important to make sure that you do that.
So this is like a work for hire clause, or
It's
something
similar to
like
work for
that?
hire and copyright. You're probably familiar with work for hire, but you'd have the same type of clause in the context of patents and even trademarks potentially.
Okay. And does an NDA kind of protect your IP a little bit there too, as well? A non-disclosure type
Yeah,
agreement?
so that is exactly what you'd want to do. Ideally, so this is a dilemma that a lot of my startup clients face, right? Which is that, yes, absolutely, 100% agree, Sophia. You want to have everyone that you let in on the secret, if you will, be under a non-disclosure agreement if you can, right? So that's important. Although I will say this, if you're trying to pitch your idea to larger companies, my experience is that they often don't want to sign an NDA. They'll send some letter back to you and it says, hey, Sophia, we got your, invention, we'd love to look at your invention, but we will not sign a non-disclosure agreement. We will respect any patents that you have or will have in the future, but basically that's it. And I think it's because a lot of these companies, they just don't want the liability of a lot of small NDAs out there. Anytime you sign a contract, you have a potential liability, right?
Right.
So they don't want to do that. So then you're in a position where, you're deciding, is it worth it anyway? Now, again, that goes back to having your patent application on file. At least if you're patent pending, at least with respect to that invention, you're protected
Yeah.
to a large extent. Now, I would rather have both patent pending and a non-disclosure if I can
Right.
get it for the client, because a couple of reasons. One is that you have more than one bite at the apple if you did get in a conflict with somebody, right? Because let's say they ran off with your technology, right, and started selling it without cutting you in, right?
Hmm.
Well, you could sue them on the patent, right, that you ultimately get, hopefully, and you could sue them as breaching the non-disclosure agreement, right? And sometimes breaching the non-disclosure is an easier lawsuit than proving patent infringement, right?
Right.
It covers more things. It takes a long time for the patent to get through, so that can be a huge benefit as well. So I'd rather have both. But if you can't get the NDA, you have to decide from a business point of view whether it's worth doing, understanding that after 18 months of pendency, in most cases, your patent application is going to be public record anyways. So how secret is it at that point anyway? A lot of people come to me understandably concerned that, okay, somebody's going to run off with my invention and cut me out of it. And I'm sure that happens out there. I'm sure it
Yeah.
does, right? But you know what happens like 1,000 times more often, in my opinion?
Nothing.
What happens is people start to fail because they don't sell enough, right? They don't make enough money. They don't manage the businesses well enough. And it just dies that way. And so if that business relationship is going to be valuable enough, you can make a decision, hey, it's worth it here. We're on file with the patent office. Okay.
Yeah.
We'll tell them about what this
Let's
is.
just do it. Well, and speaking of infringing on IP, how early in this process should I find out if I am infringing on someone's IP? Where do I look? How do I know?
This is hard because it isn't always very clear. You really have to do a full search and analysis to really know. But so that might be what you do, right? Just hire patent counsel to do a full freedom of analysis workup on this.
Oh, like freedom to operate.
Freedom of operation.
Yeah.
Sorry about that. Freedom to operate. Now, there's two different types of patent searches generally that we might do. One is patentability, right? You've got an invention. Let's say you think we can get a patent on it, right? And then there's a second analysis, which is actually quite different, called freedom to operate, which is, okay, I want to sell this product. Are there patents blocking me, right? Those are totally different, because let's say there was a journal article describing your invention published last month, right? In the Journal of Widget Technology, right? Well, that is prior art against your patent application, but that has nothing to do with whether you can still go sell the product, right? Because that's not a patent or patent application or anything that would stop you, right? Let's say sometimes you have situations where there's an old expired patent that covers it. Well, that again will stop you. Surprising how many clients actually don't understand this with the patent system, but yes, if a patent expires, you can't just go in and patent it again.
Oh, come on.
I know. Some people ask me that one, but I mean, it's understandable. Hey, it's a good question to ask, right? If there's an expired patent, you can't get a patent on this, but you can go ahead and sell it if you think you can just compete in the marketplace without having, any kind of protection there on competition.
So what would be your final words of wisdom for a founder who's going through this and going through kind of a little pre-launch checklist?
Yeah, so I think it goes back to just, get a quality patent counsel on your team early, right? Just take care of those basic filings. Getting your technology on file with the patent office is really number one, because there's real devastating consequences if you don't. And then just start looking at your trademark portfolio, talk about non-disclosures, just bring all this stuff up early in the process so you don't have to play catch up later. It's all.
I love that. Thank you for your wisdom today, Mark.
All right, no problem.
And thanks for joining us on Inherently Distinctive. To connect with Mark or learn more about protecting your IP, visit goodmanlawnevada.com. And remember to like, subscribe, and review the show, and we'll catch you on the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.